The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone. My name is Christopher Cahill, 12 Points Wealth Management. Thank you for joining us today. We're going to cover October's webinar, which is Essential Legal Documents, what you need to protect yourself and your family. I'm going to just give us another moment here to begin, but I do want to be respectful of your time today, so I'll probably start in just a moment or so. So be right back to you, and we'll get going in a minute. Thank you. All right, without further ado, we're going to get going here. So as I said, Christopher Cahill, 12 Points. I'm an attorney by training and background. I no longer practice. However, I have the distinct pleasure of being a partner here at 12 Points Wealth Management. I'm also a certified financial planner and a chartered advisor in philanthropy. My practice and focus is centered around working with affluent individuals, business owners, C-suite execs, and I have a particular expertise and focus on working with lawyers and law firms. And what we're going to cover today is an area that's near and dear to my heart: estate planning, legal documents. This is something that I spend a lot of time talking with my clients about and others, and I'm very passionate about the subject. So forgive me if I get a little excited here throughout this, but there's things that I feel are really, really important. So we're going to kind of jump right into it, okay? So estate planning, really important to understand that you don't need to be a millionaire to start thinking about the importance of estate planning. Everyone has to have an estate plan. Why? Absent an estate plan, you're leaving many, many things to chance and to decisions from others that you may not, in fact, want. So what do I mean there? If you don't have a will, you're going to be what's called intestate. The state will determine where the assets go. That's a lousy result. If you don't have a healthcare proxy, those that love you can't help make informed decisions for you if you're incapacitated as it relates to your healthcare. If you don't have a durable power of attorney, people can't manage your finances if you're disabled. So all of these things are important for all of us, never mind the mega affluent. So know that estate planning is important for all of us, not just the mega wealthy. So today we're going to cover living wills. We're going to talk about living trusts, wills, durable powers of attorney, healthcare proxies, medical directives, HIPAA authorizations, and we're going to also finish with some stuff relative to prenuptial agreements, etc. So without further ado, let's continue here. So living trusts, you've probably heard people say, I have a trust. What is a trust? Well, a trust is a vehicle that really divides the ownership of property between a trustee and a beneficiary. So a living trust is also known as a revocable trust, meaning it can be changed, altered, or amended. A really great planning tool for most of us out there is to have a revocable living trust. This will allow you to put assets into a trust, be able to manage it as though it were your own assets, because they are. It will handle the distribution of the assets that you're passing. It will keep assets out of the estate. So what I see is there's tremendous benefits to the utilization of revocable trusts. It's something that I think not enough people use. The pros here, as you see, allows you to control the property both during and after your passing, as I just discussed. It really can be used for any size estate. It definitely avoids probate. It allows you to plan for the future and is an excellent way to manage wealth in the event of incapacity. So what do I mean there? If you become disabled and you don't have a revocable trust that's funded with your assets, whoever you've been fortunate enough to name as a durable power of attorney, hopefully you've done that, will be in charge of making financial decisions for you. Those poor folks are going to be running around to banks and to financial institutions, etc., with a document entitled durable power of attorney. And these institutions really are loath to operate under a durable power of attorney. They oftentimes go out of their way to not pay attention to them and find reasons to not listen to the person holding them out of fear of liability and risks to the institutions. If you have your assets in a revocable trust, on the other hand, the trustee is going to be the person in charge. If you're disabled, the durable power is still effective, but not necessarily necessary. The trustee will be able to go out to the banks and institutions themselves, and they'll be able to operate as the owner of the property. And institutions, banks typically listen to trustees better. They like to see a trust document. It makes them feel more comfortable. So this is an area that's often overlooked, but utilizing revocable living trusts is really wonderful. It's an area that I think that you should give consideration to. A little bit more expensive, certainly, than simply using a will. There are the benefits that we talked about, getting assets out of probate, providing for incapacity. We do oftentimes see people spend money on a revocable trust and not fund it. That's an area that you want to avoid. What do I mean by that? Funding the revocable trust is taking the assets that you have, whether they're investment accounts, cash, real estate, business assets, putting them into the trust, having the trustee be the owner of those assets. That's the only way the asset remains out of probate, folks. If you don't do that, and the assets pass through your will, by definition, they're going to go through probate. So make sure that if you do a living trust or a revocable trust, that you actually take the next step to fund it. Really, really important stuff. So irrevocable trusts. These are vehicles that are used to limit the estate tax burden typically. So for the affluent, they're really great ways to move assets out of the estate. If you can get rid of all of the incidents of ownership of a property, a policy, life insurance policy, or an asset, and put it into a trust, it will remove that asset from your taxable estate and all the growth that occurs thereafter. So the pros of using irrevocable trusts is that it relieves the asset from being subjected to estate tax in your estate, and it can remove the tax liability from you depending upon how the trust is structured. I'm not sure that I really like that. I mean, oftentimes I like to have the taxes paid by the grantor, the person creating the trust. It's a great way to get additional gifting and a way to move assets to the beneficiaries by removing the liability for the taxes from them. So irrevocable trusts are important, and they're definitely vehicles that should be considered, particularly with regard to life insurance. Life insurance in the irrev trust is really wonderful. A will is kind of the linchpin of anybody's estate plan. This is in case of you don't do a trust, at least do a will. This will show where you want the assets to go at your passing. It will also allow you to name and appoint a guardian for any minor children that you have, which is a huge, huge thing. So many people forget that. This is actually one of the reasons why people don't do their legal documents that we see quite frequently, is they can't agree on who the guardian's going to be. Don't get stuck in that trap. Pick somebody and create a will. In Massachusetts, it needs to be written, you need to be over 18 years of age, you need to have sound mind, and it needs to be witnessed. So wills are really critical. You can have a will that's called a pour-over will. You see that right here. What that means is the assets would pour from the will into the revocable trust. So ideally, you would have already put all of your assets into your revocable trust, and the pour-over provisions would be meaningless. But oftentimes, there's things that people forget to put into their revocable trust, and the pour-over will be a vehicle to hoover them up and push them over there, for lack of a better term. We talked briefly about powers of attorney. Powers of attorney are really, really important. They really grant the individual, the agent, legal authority to make decisions on your behalf. It's very simple. So if you become incapacitated, your bills have to get paid. The importance of a durable power of attorney really can't be understated. The term durable means that it's going to survive past the incapacity of the principal. If there's not the magic language in there saying that it will survive the incapacity, many individuals or institutions and courts will not allow it to be utilized for that purpose. It's kind of a lousy result, to be honest. So you need to be careful who you give one to, obviously, right? Because this person is going to be able to act in your stead on your assets. So please be careful about who you give them to. You can have limited and special powers of attorney. Probably seen this before. If you've sold a piece of property, maybe you don't go to the closing, you give a power of attorney to the attorney that's handling the closing for you, for that way he or she can go sign documents on your behalf, that sort of thing. Really important, can't stress it enough, get a durable power of attorney. Healthcare directive, otherwise known as a healthcare proxy. This is really critical. This will allow people to access your healthcare information if you become incapacitated. So they'll be able to make decisions for you. And you know, if you're not in a position to make those medical decisions for yourself, you certainly want to give that authority to somebody that you love and trust. HIPAA authorizations. This allows the person, presumably, that you've given your healthcare proxy to the ability to access your personal protected medical information. Really, really important to be able to get that information. If the institution that you're being treated at doesn't, if you don't have a HIPAA authorization on file, they're not going to share your records with the folks that you want them to without a court order. And as a result, you're going to end up having a really challenging time for your family members. And that's just really what we're trying to prevent here. And we want to make sure that you and your loved ones are taken care of. So transitioning here into child protection plans. A child protection plan is a set of instructions, legal documents, identification that allows for the smooth transition of your children's custody in the event of tragedy. So this is guardianship, etc. Really important. Can't stress it enough. If you become, something happens to you, whether you become incapacitated permanently or you pass away, you have minor children, you need to make sure that they're taken care of. You want to make sure that you don't have these ugly custody battles, and you can ensure that by putting that in documents that are executed properly, notarized, etc. You want to provide for that specific discussion about assets to use for the care and custody of the children. And you really want to prevent having to have temporary custody with others that you wouldn't have chosen if you failed to do this. So prenuptial agreements, can't say enough about prenuptial agreements. If you have assets and you're getting married, consider a prenup. Prenuptial agreement is going to allow you to decide in front of the marriage how assets would be divided in the event that you had a divorce. Let's face it, 50% of marriages today, give or take, end in divorce. You need to be thoughtful about that. It's basically a legal contract, as it says here on the screen. They're often used by wealthy folks, and it's really used to protect the assets, right? There's often a family business involved, and mom and dad will say, well, if you're getting married and you're going to own any part of this business, you need to have this document in place. We will provide for the basic division of the assets, clearly define inheritances, spousal rights, whose debts are whose. You need to do this well in advance of the wedding date, folks. You can't pull out a prenup on the wedding day and say, sign this. It will be completely invalid. No court will uphold that document. You need to get this done well in advance of the marriage. You need to get attorneys involved. There needs to be full and complete disclosure of assets. And absent that, they're just not going to be valid. So I don't know that I would waste the time and energy on it if I wasn't going to feel confident in it being upheld. So the sooner the better. Obviously a hard discussion to have, but again, for those of you that have the assets and or the family with the assets, this is something that is oftentimes a requirement, candidly. So pay attention to the prenups. What does it do more specifically? We're going to divide the assets and we're going to clearly define the inheritance. So spouses identify all of their assets, as I said, coming into the marriage. And oftentimes what you're going to see is one spouse has no assets. Maybe they're just in debt even. They have college loans, and the other might have millions and millions of dollars. The assets listed can easily be split according to the agreement, prevents the messy or drawn-out divorce proceedings, and you really want to minimize the uncertainty of a divorce proceeding and or the costs associated with it. Also, inheritances, again, if we have one spouse with significant assets, one without, or you could have two people that have significant assets and they want to just make sure that what's his is his and hers is hers. That's fine too. So defining the inheritance is also closely defined. It is also closely aligned with dividing the assets. So, really want to make sure that we have the prenup identifying the spouse's assets that can be expected through an inheritance and can prevent the children from going to court and getting into a nasty litigation thereafter. So what we're going to do next in the prenups is we're going to identify the spousal rights. So what do you get? If in the event of a marriage dissolving, the individual assets become shared assets. Well, not in the event of a marriage dissolving. At marriage, individual assets become shared. So prenuptial agreements can encourage the legally binding division of assets from separate bank accounts to trusts, etc. It's better to know what's yours and what's not. You can also use these to protect oneself from debt. So if you have one spouse that has a significant amount of debt coming to the marriage, a prenup can carve that out and have that remain theirs. And that's something that can't really be overstated as well, the importance to paying attention to whose assets and liabilities remain where. So we spoke about this before. During a divorce, courts are going to review the prenup very closely to ensure that it was fair and it met the state's legal requirements. If you're thinking about a prenup, you should engage competent counsel up front. Who would be competent counsel? It's not going to be your mom and dad's corporate attorney. It's not going to be your real estate attorney. It's going to be a family law attorney in conjunction with an estate planning attorney, one or the other of those two people, but definitely not somebody that's just ripping a document off of legal forms. You want somebody that's done a lot of these, because if you're going to take the time and energy, if you're going to broach this subject, folks, have it be worth the pain, because it is a painful conversation. You want to make sure that it complies with all applicable laws and regs, and note, even the best drawn document is not going to prevent somebody from attacking it. So in the event of divorce, expect that they're going to come after the document trying to invalidate it for whatever reasons. So, it's really, really critical to pay attention to these documents well in advance. Make sure you have competent counsel. They are going to be expensive because you're going to need them done correctly. At the bottom of this page, you can see here postnuptial agreements. Important planning tools as well. What's a postnuptial agreement? That's something that says, hey, we're married. We're at a point in our lives where we've created significant wealth, or there's assets, and we're not planning on getting divorced now, but in the event that we do divorce in the future, we want to set the stage as it relates to these assets. So it's kind of it's the same sort of conversation that you'd have in advance with the prenuptial. You're just doing it after the marriage. There's many instances and reasons that this would come up. Maybe at the time that you got married, you didn't have any wealth. After the marriage, one of the spouses either inherited assets or had a business that became very successful, or they became successful doing something else, and there was an asset mix that made it such that one wanted to protect that. It's a tough conversation. You don't have a whole lot of leverage, to be honest, at that point, but they are viable documents, and they can be really, really important at certain circumstances. So just know that those are documents that can be executed and looked at. So the importance of prenups and postnups are often overlooked. Many people should have them and don't, for the obvious reasons. They just can't deal with the struggle of getting through that conversation or getting their spouse to agree candidly. So to refresh, the core legal documents that one would need, whether we're wealthy or not, is a will that will dictate where your assets go at your passing. It will appoint a personal representative to handle the assets, should there be any that are in your estate. It will name a personal guardian for the children, critical. It will set up trusts in that document if you're going to be utilizing it as testamentary trusts. Otherwise, more hopefully, it will pour over into a revocable trust, that document that we spoke about up front, or a living will. That document will allow you, whilst you're living, to manage assets as though they're your own. They'll allow a trustee to manage those documents if you become incapacitated, and then they'll allow for the distribution of the estate in the manner that you see fit after your passing. So a revocable trust and will are two of the linchpins of a successful estate plan. Also need your durable power of attorney, your healthcare proxy that we discussed with a HIPAA authorization. And then on top of that, ideally, you'd have some insurance in place for your spouse and your children. Preference for owning insurance, from my perspective, is in an irrevocable insurance trust to keep it out of the estate. Protect those assets from the creditors and predators of your beneficiaries. That's an area that we didn't talk about at all as it relates to the trusts. Let's go back and talk about that for a moment. What do I mean by protecting the assets from creditors and predators? So when the assets are distributed through your estate, either through your will or through the revocable trust, they can either go directly outright to your spouse or your children, or they can be held in trust. What's the best thing to do? I significantly prefer utilizing long-term trusts. I'm a big proponent of utilizing trusts. I like to say, put your trust in a trust. Why? If an asset's distributed outright to a beneficiary, they own it, they control it, and if they're in the middle of a divorce, if they're in the middle of a lawsuit, or if they get into a car accident, or if they're just a spendthrift, they just aren't good with money. All of those things can see that wealth and that hard work that you put together and the asset that you've identified as a legacy for that beneficiary get dissipated and or lost or ordered away via some sort of judgment. That's a bad result. How do you protect it? Keeping an asset in trust where the beneficiary is not the sole trustee, that's how you do it. The trust can dictate that there's discretionary distributions to the beneficiary. The beneficiary is going to be able to receive those distributions from the trustee, but if there's a decision on the trustee's part that it would be imprudent to make a distribution, then they'll hold it back. What would be an imprudent distribution? If you had somebody that was a drug addict, if you had somebody that was in the midst of a divorce or about to be in a divorce, or they were subject to a lawsuit, those sorts of things. So utilizing a trust long-term for the benefit of the beneficiaries is really, really critical. You may hear this term, a generation skipping trust. We utilize those for many of our clients, and what that simply means is you're going to hold the assets in trust for multiple generations, right? So what that's going to do is going to provide your children, say they're the primary beneficiaries of the trust, they're going to get discretionary distributions of income and principal from the trust as needed. And when they pass, the trust will continue to contribute to the benefit of their children, your grandchildren, so on and so forth. So what that allows is for the assets to be held and protected for generations and keep it out of the estate tax realm for as long as possible. So this discussion here isn't centered specifically on estate taxation, so I'm not going to get into the minutiae and intricacies of the generation skipping transfer tax or the estate tax itself, but just know that long-term trusts set up appropriately in jurisdictions that don't have a rule against perpetuities can really be a wonderful vehicle to create what I call a family bank or a dynasty trust. So that's kind of around the world with legal documents. We like to get these things in and out within a half an hour, and I'm just approaching that time period here. So I'm going to bring this thing to a conclusion. You can see my contact information here. My phone number is 978-318-9504. The email is chris@12pointswealth.com if you have any questions. We're here to help in any way, shape, or form that we can. We have a whole network of really qualified, competent trust and estate attorneys that we work with on a day-to-day basis. As I said before, although I am an attorney, I no longer practice, so I won't be drafting the documents for you, but I can certainly help guide you through the process and get you to the right individuals for you and your family to make sure that you get the documents that are appropriate. And what I would suggest also is that once you have them, don't assume that they're good forever. You need to review these things. I like to tell my clients every 3 to 5 years, let's get the documents out and review them. Times change. You might make a decision that you want to have one person be your guardian and then have a falling out. A trustee could pass away and the successor may no longer be somebody that you think as fondly of. Whatever the case may be, there's a whole host of reasons to review and pay attention to these documents. You don't want to do it all the time, certainly, but every 3 to 5 years, I think it's appropriate to pay attention to. So I want to thank you all for joining us today. And this webinar, like all others, has been recorded and will be posted to our website shortly. So if you came in late, know that it'll be up on the website and you can come back and listen to it at your leisure. It's also a great place to go listen to our other websites and, our other webinars. So they're all up there for you. And I appreciate your time and energy today. Get back to lunch, enjoy the day, and we'll talk soon. Thanks very much, everyone.